Hello, everyone. My name is Juliet Alcoba. I'm an attorney at Alcoba Law Group. I'm a Florida licensed trademark attorney, to be exact. And today I thought it would be a good start for us to discuss the right time for filing a trademark. It all depends basically on where you are in your business. If you started offering your services already, and of course, if you're just brainstorming, coming up with what's my next step, what am I going to do? The quick and easy answer, of course, is the sooner you file, the better for you in the long run. But that's in a perfect world, and things happen, things get in the way, so it might just end up being that you end up filing, maybe a few months, even years after you've actually launched your products and your services. So some of the main reasons why you want to go ahead and file early in the process of launching your products and your services is, of course, it reduces the risks that you could have down the road, like in the sense of like, well, are you going to be having to defend against a lawsuit? Are you going to want to bring a lawsuit? Having that registration, the federal trademark, is really going to help you. Just generally speaking, there are several types of trademarks you could have. What we'll be discussing today will be a federal trademark. And the reason why I'm going to suggest to you that you go ahead and file for a federal trademark is because your ability to expand and offer your products and your services won't be hindered theoretically, right? There always could be something that happens, but in a perfect world, you get your federal registration, you could offer your services in every single state of the United States, and of course in our territories. But so that being said, that's what I will be stressing today, the reasons why you would want to file for your federal trademark. Again, it's not fatal to you that you didn't file for your trademark the second that you opened your business doors. There's the reasons why I would stress that you do this sooner is that it's not a 1, 2, 3, you filed your application and your registration certificate arrives the next day. It's nothing like that. It's going to take several months for you to get your trademark registered. So, it will give you a lot of peace of mind, basically, by starting the process early, because if for whatever reason after you file, the name is not available to you because the examining attorney that's assigned to your case says that it's confusingly similar to someone else's brand, that's assigned to you. Well, what do I do now? Do I invest in rebrand myself, or do I fight and continue the process? Everything just depends on how long you've been using the name that you've applied for, and you take it from there. But in a perfect world, when you file in 8 to 11 months, you'd be given either your registration certificate or you would be given a notice of allowance. And really what separates you from getting the notice of allowance and the registration certificate is, of course, the type of application that you filed. If you are intent to use, which means I haven't started using this name, this design, this logo with my products or with my services, it's something that I want to be using. So that in that case, you would get a notice of allowance. And then if you were one of the people that were able to file and at the time of filing, you had all of the licenses that you needed. Of course, you don't submit those to the Patent and Trademark Office, but that you have proof that you're actually offering your services, that you've launched your product line. In that case, you would be issued your registration certificate. But all of that being said, is just stress that it's not an overnight process. It takes 8 to 11 months to really get some type of assurance, if that makes any sense, from the USPTO that the name that you're applying for, you're actually going to be able to get. So all of that, again, is just to stress, the sooner you file, the better. It reduces potential litigation down the road. It enables you to expand and enter different, states with ease and comfort to people that are maybe interested in purchasing a franchise from you. So that's another thing, depending on how you feel about your success once you actually launch your products and start offering your services. Like if you've been doing it for several years, the next step would of course be, well, you have a conversation with yourself and you see, well, is this appropriate for franchising? And then so that's where the trademark again becomes extremely valuable to you, because then it enables you to convince people to invest in and help you further the growth of your business, because they have that, security in a sense that the name that you're licensing to them is available for their use in the states that they're going to be working on, like working for you. So that's pretty much the reason why the sooner you file, the better. Again, just breaking it down to bullets, it reduces the potential for litigation. You're going to be able to expand into, and offer your services all throughout the United States. And of course, it's just a prerequisite for being able to eventually franchise the business that you actually end up developing and rolling out. So if I typically have a lot of questions about, how long it takes. That would depend on the type of application that's filed. So whether you filed as intent to use or in use, and I did a bunch of rambling about that, saying it could take 8 to 11 months. But if you filed as intent to use, what ends up happening, it's obviously longer than 8 to 11 months, because then it flips back to you, the applicant, and it becomes a conversation. Well, the reality check with yourself is, how long does it take for you, the applicant, to roll out what you wanted to roll out through your application? Like if you said, oh, I'm going to manufacture and distribute a whole bunch of a cosmetic line, and so maybe you get your name approved in 8 to 11 months, but you're still sourcing products. So you're still negotiating with manufacturers. You're still designing your labels. So that's when it becomes, well, how long could it take? Well, it's however long it takes for you to get it together to submit your proof that you've launched. But something that happens that I mentioned earlier, oh, here we go. If, for instance, you have a business that's open for, let's say, 10 years, and you didn't file for a trademark, it's not the end of the world. But what could end up happening is that when you do take steps to register your business, right, or not your business, but you do take steps to apply for and register your trademark on the national level, what could happen is that there could be someone else that maybe they knew about you, maybe they didn't. But the point is that they filed for a trademark before you, and they got approved, and then they could be blocking you from obtaining that federal registration. So in that case, what would you do? Well, there's multiple things you could do. You could contact that person and try and, have them sign a coexistence agreement, a consent agreement, basically allowing you guys to, offer maybe similar services using names that are similar and hopefully not identical. But if you were doing so, like reverting back to the whole, if you're in business for 10 years, you're in a really strong position. Maybe if you can't convince that person to sign a coexistence or a consent agreement, just to continue doing what you've been doing in peace. Of course, what could happen there is that you would be limited to what we call the geographic zone. Well, like where you actually have offered your services is where you would be limited, or like forced to work with, if you're not able to convince them to let you go forward, or if you don't take aggressive action against that person that maybe's blocking your application. And when I say aggressive, that means that there are certain things that you can do to overcome these kinds of hiccups that come up when you wait too long to apply for a trademark. And so you would have to, every situation is different. So it doesn't necessarily mean that it's a slam dunk and you're going to be able to, cancel someone's application or registration that registered because you weren't paying attention and you didn't file for a trademark and they did. Or let's say that person didn't have a registration, but you found out about them, but you see that they're earlier in line from you. And so they're basically preventing you from registering, but they don't have a full-blown registration. And in that case, you would consider filing an opposition against them. But, it is very expensive to do all of those things. So you want to analyze all of the avenues, all of the options that you have before you commit. Of course, if you've been in business for 10 years and you've made significant investments in developing, your reputation, you have clients, you have clients in California, you have clients in Texas, you have clients in New York, because you've been advertising your services online, that it would weigh in, and you would really want to have a conversation with yourself or with your partners or whoever's really involved in the business, your attorneys, about how strongly you feel about getting that federal registration. When you're a service provider, there's of course, there's a lot of things that you can do to boost your rankings with SEO online through Google, but Google has a lot of resources available. You can register your trademarks with them, and then they could help. They could prevent other people from using those names that you've successfully registered in marketing campaigns that are similar to, and for people that are providing similar services to what you in fact are doing. So the federal registration, assuming you get it, even though you waited 10 years to get it, whatever, that's not a big deal. If you did get it, you'd be protected in all 50 states and U.S. territories. So another question that has popped or that's come in is that basically, so let's say you did get the registration certificate. What do you do? What do you have to do to maintain it? So basically, the USPTO has they've become increasingly strict. So they're asking, they've always required you to basically, to prove this, to submit proof that you are actually offering the services that you list in your application that matured into a registration, and to just continuously submit proof of your product line. It's not something you do every year. If we, like, say, for instance, you applied for an in-use trademark application, at the time that you file your application, you'd be submitting that proof of product or that proof of your services at the time of filing. And then 8 to 11 months after you file, assuming it's a perfect example, like a seamless, perfect process, there are no objections, blah, 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 then your renewal, in order to maintain it, your renewal date would come. It's really interesting because you have different dates depending on what anniversary you are about to hit. So your first anniversary date or your renewal date, maintenance date, whatever you want to call it, is between the 5th and the 6th year. Then your second renewal date is between the 9th and the 10th year. And when I say the 5th and the 6th and the 9th and the 10th year, I'm saying those years following your registration date. So knowing your registration date is very important, just for long-term, for maintaining your trademark. But the first 10 years are pivotal. The first deadline, of course, being between the 5th and the 6th year. The second deadline being between the 9th and the 10th year. And then after that, once you've hit that 10-year mark, then your renewal periods would be every subsequent 10-year period. And at that point in time, you would just repeat what you did at the time that you filed your initial application, which is you would submit proof of your products, submit proof of your services. They've begun doing there's a lot more of, I guess, auditing going on. So if for whatever reason at the time you filed for your application and you had listed, and you actually submitted proof of, cosmetics, if not cosmetics, hair care products, clothing, any type of product that you started or that you had started your business launching or your product launch. And at the time of your renewal, if you've perhaps stopped selling one of those items, at that point in time, you as the registrant are supposed to go ahead and delete the reference to that item because you're no longer doing it. But of course, that is, of course, with the belief that it's something that you stop doing with no intention of resuming to sell, if that makes any sense. So it's really like an honor code thing, but be very careful because it's not something you want to deal with. You don't want to deal with the kickback of, you've been randomly selected, and out of the 30 items that you had registered, in whatever 2015, now it's time for you to renew, but you only submitted proof of maybe 5 or 6, And then they ask you, well, where are the other, 24, 25 products that you listed in your application? And then, you're going to have to deal with, well, submit samplings of, invoices, sales. Like it just becomes this whole Q&A that you don't want to have to deal with. So honesty is the best policy. Make sure that your items and your registrations are accurate and up to date, and just avoid those hiccups that could come along the road when you're doing your maintenance and renewal. But I don't believe there are any other questions. And I think for the purposes of today's live stream, that I've been able to cover the general reasons of why you should file for your trademark, sooner than later, And if for whatever reason there are any concerns that were not addressed briefly, feel free to email me. My email is jalcoba@Alcoba Law. And again, my name is Juliet Alcoba. And more information about the services that my firm offers, of course, is available through our website, www.alcobalaw.com. Thank you. And feel free to email me whatever questions you may have.